Welcome, everybody. This is Matthew Curtin. I'm an attorney at the law firm of Murtha Kalina. Thank you for joining us for today's webinar, Social Media in the Workplace. Before we begin our presentation, here are some housekeeping items. All participants are in listen-only mode. If you have any questions during the presentation, please write them into the questions box on the webinar toolbar, and we will answer those questions at the end of the presentation. This webinar is being recorded. After the presentation, all of you will receive a copy of the PowerPoint slides, the webinar recording, and an attendance certificate. And I'll just note that this is an informational webinar and we are not providing attorney-client privileged advice during this webinar. With me today is my colleague, Medea Malik. We're excited to talk about social media and the workplace. This is a topic of significant importance to everybody today, as far as I'm concerned. We're going to be talking about the use of social media in making personnel decisions. We'll be talking about the use of social media at work by employees. We'll be talking about employee use of social media outside of work. We'll be talking about best practices about how to handle social media in a variety of different contexts as well. What is social media? I assume that mostly everybody, if not all, on this phone call knows at least a little bit about social media, and if you don't, I encourage you to educate yourself on social media because it is ubiquitous. It is everywhere and it permeates all facets of our lives these days. From Facebook to Twitter to Instagram to LinkedIn to Snapchat. These are just some of the more well-known social media platforms. There are voluminous other social media platforms that are out there today. Some come and go, some stick, but there are a variety of social media platforms that your employees are utilizing, and they're utilizing them for many different purposes. They're utilizing those social media networks as virtual communities. They're using them as today's water cooler. Employees use social media today to gather and discuss workplace concerns, what they like about the workplace, what they like about management, what they don't like about management, personal gripes about pay, about benefits, or they might gather and talk about what they do like about their pay and they might try to encourage other people to come join your company. Social media can be used for so many different ways that you really have to have a basic understanding of what it is and how it affects your company. Because social media, we're going to talk about some of the pitfalls of social media in employment today, but it can also be used in very positive ways, and savvy employers are using it and leveraging social media for marketing and for branding and to project a workplace for employees and for potential employees that show to try to lure the best talent out there and to try to retain the best talent. Also, social media can enhance productivity by fostering connections with colleagues and resources around the globe. It's really true. Social media has, in the words of Thomas Friedman, the world is flat. And social media has enhanced that and sped that up. Social media isn't just available in the United States, obviously, it's available everywhere in the world. So you can have an international company and you can be using social media to leverage that platform for collaboration and connections with employees on a real-time basis all over the world in many different ways. So it's a very useful tool. It's great to have an understanding of it, to figure out what kind of social media platforms work for your company, but you also have to recognize that there are pitfalls as well. And we're going to talk about some of those pitfalls, but before we do that, let's just to drive home the point of how ubiquitous social media has become. Medea is going to highlight some statistics for you.
Right. So today, around 7 in 10 Americans use social media to connect with one another for various reasons, to engage with news content, to share information, and just for entertainment. Facebook is the primary platform for most Americans, as we can probably guess. 68% of U.S. adults are Facebook users, and of them, about 3 out of 4 access Facebook on a daily basis. So really, that is the primary social media platform today. Research shows that 77% of U.S. adults use social media at work, which is part of the reason why we're talking about it today. 34% of those individuals say that they use social media at work to take a mental break, and 27% say that they use it at work to connect with family and friends. And other statistics show that employers are using social media now. 70% of them are using it to screen potential hires. And we'll talk about how social media can be used in the hiring practice. And one thing I want to note is that the research shows that youngest adults, as we can guess, stand out in their social media consumption far above the older generation. And this really is the future workforce. You know, millennials have grown up using social media, and it makes it all the more important for employers to become familiar with issues surrounding social media use, because it's going to become more and more prevalent in the workplace if it already isn't.
Yeah, and if not already, millennials are about to overtake the baby boomer generation as the most populous workforce segment. And millennials, especially the younger end of the millennials, have grown up with social media, and they're familiar with living in social media. Many of them use that as the predominant way to socialize and to connect with others. It's not face-to-face communication anymore. It is Tinder. It is Facebook. It's Snapchat. And that's how millennials are corresponding, communicating, researching, trying to look for employment. Google Jobs, Monster, Indeed, all of these types of platforms are really becoming the predominant way how the younger generation looks for jobs and how they talk about potential openings and how they assess their career moves. So it's important to understand social media and to try to use it to enhance your culture and your branding. So here we have Batman and Robin fretting over the fact that their Facebook page is it's not in good shape. And so Batman's asking Robin, what do we do, and what would Zappos do? And a lot of employers, they're having this discussion. They're saying, why is our Facebook page in bad shape? Why is our Instagram page in bad shape? And they're trying to figure out how to use it and how to use it to market, to brand, recruit candidates. And to the extent that employers don't use that, it could be a missed opportunity. But what are some other benefits as well? Background checks, informal background checks, personnel investigations. Social media can be used for these purposes, and it can provide some very useful information that 20 years ago you just would never have.
So just to touch on a statistic I found on recruiting candidates, 95% of recruiters say that they use social media to post and promote job openings. So that's almost all recruiters. And 59% of employees or prospective applicants say that they choose their current workplace in part because of the company's social media presence. So it makes it all the more important for employers to monitor their company's public profile. You know, as Matt said, there's no classified ads anymore. The primary way that people are looking for jobs is through Google. And what they find on Google might not be what the company has put out, but the company has to monitor what's out there and what other people are consuming about it.
Yeah, you can. If you put in an employer's name, you might get some negative reviews on Glassdoor or some other review site or Yelp or whatever. And savvy employers are monitoring these issues and trying to stay aware of what's out there on the internet and in social media, what's being said about them. So let's talk about managing social media at work a little bit. Primary question. So let's pose the question: is it okay? Is it okay to allow social media or to block social media at work? And again, so this is the question: is it okay to allow social media for employees while they're working, or is it okay to block it? It depends on really what your work, what's appropriate for your workforce and what is appropriate for your culture. There can be questions of lost productivity if social media use is allowed. But also social media can be used in a number of ways that are positive for entities, for research, for staying abreast of news. Can you block social media usage at work? Sure, and if you're using employer-owned devices and you want to implement safeguards on your network that block social media like YouTube because it's consuming too much network data or because of a loss of productivity. But again, you got to keep in mind that bring your own device is becoming more and more prevalent. And if it's an employee-owned device, and you're not going to have an opportunity to block social media, and your employees are going to have access to social media whether or not you block it on employer-owned devices. So the question then becomes, do you have policies in place that prohibit the use of social media or personal internet consumption while on working time? And really the question goes to, is this a driver of productivity, or is it a negative productivity aspect at work? And what's the positive side of using social media, and what's the downside? And it can be different from employer to employer. Is it social media fundamental to the company? That goes in line with the question of whether or not you want to allow social media use or block it. Believe me, all the employers in Silicon Valley, they're not blocking social media because they know their employee segment. They know the employees want to use social media, and it's an integral part of their company. But for a small manufacturing outfit that might have 8 employees, and the employees work on a shop floor and don't have access to electronic equipment that's issued by the employer, is social media going to be fundamental to that company? It might not be fundamental to the company's mission, but that employer, even though it's not fundamental to the company's mission, has to recognize that their employees are probably still bringing devices with them to work, and that those employees still have access to the internet and social media websites or apps. So it's really, getting an understanding of social media, how it's used in the workplace, and how your employees are using it and when they're using it is really critical to figuring out productivity issues. Is it okay to use it in workplace investigations? Yeah, and it's using social media at work, the purpose of workplace investigations is certainly appropriate, but it needs to be done correctly, and we're going to go over that a little bit more.
So let's first talk about employers using social media and what the positives and negatives can be for using it in the hiring process. So some of the positives are that it can enhance background checks and be helpful in a hiring decision. So those kind of go hand in hand. As a rule of thumb, if information is public, if the social media page is public, it's fair game. You don't need to get authorization from the individual to access someone's social media page if it's public. And, that can lead to finding reasons to hire or not hire candidates. If on a Facebook page or on a Twitter page it says, I really hate working, I'm not interested in my job, or I'm not interested in finding a job, that can lead an employer to think that this person is not the right fit and question what kind of work ethic they're going to bring if they are hired for the position. So in some ways, it can reveal information that you might not get during a job interview. The job interview sometimes is the person obviously putting their best foot forward and showing themselves in the best light. And so a public social media page can reveal information beyond that.
Yeah, there's only, I've heard it said that there's only 2 times when a person is perfect, at birth and the job interview. And social media, it's really one way to enhance the background check process and determine if a candidate should be hired, because you might find information like Twitter posts that show that a person has insensitive racial views or has expressed misogynistic views that are not in line with your company's culture. And the person could interview very well, but then after the interview, you go and you do a quick cursory check of the person's social media feeds, and you see information that would lead you to believe that it wouldn't be a good fit. And that's how you can leverage social media for the hiring process. But Mandia, it's true that if you look at somebody's social media feed, you might also discover information that the person is in a protected category, right?
Right. So there's definitely a downside, and something to be careful about is when looking at someone's social media page might show protected information. And so if you find out that the individual is pregnant, it's prohibited for the employer to then deny that person discrimination based on the fact that they're pregnant, because pregnancy is a disability under the ADA, and discriminating against someone based on that and denying them a job opportunity would be violating the ADA. So
pregnancy is a very, if you go onto somebody's Facebook account, and there's case law, there's cases about this where employers go on to a social media account and see somebody's pregnant, and they say, well, I don't want to even bring this person in for an interview, or they talk to them over the phone and say, I saw on social media that you're pregnant, this just isn't going to work out because this job isn't fit for somebody who's going to just take the job and then be out for a couple months. That's discrimination. That's discrimination under the Pregnancy Discrimination Act. It's discrimination under Connecticut state law, making a decision based on that protected category, and you learned about that information only via social media. Same thing, it's the same for age. You could learn about somebody's age on social media and make a hiring decision. That could be age discrimination. You can make the same thing can go for protected information about a disability. There's a whole host of examples, but if you learn about protected category information on social media, and then you base a hiring decision based on that protected category information, you're asking for trouble, and you're probably buying yourself a lawsuit.
So one way that employers can protect themselves from falling into that trap is to look at the applicant's social media page after they have been interviewed. So after they've been screened, and by that point they're still being considered for the position, and the social media page is really meant to enhance their understanding of the person's personality, not necessarily trying to look for a protected trait. And so you're less likely as an employer to be accused of making a snap decision when you're making that employment decision if you wait until after the interview is conducted. And another tip is that any information that's revealed on a social media page should be viewed in the same way as if you learned that information during an interview or on a resume. So it really is, it's an extension of the resume or the interview, if you will.
So why don't we talk a little bit about the use of social media in workplace investigations?
Yeah, so social media can be a really useful tool when it comes to workplace investigation. So if there's an issue that arises in the workplace and the employer wants to find out, what the truth is, it can be really useful. And one case illustrates this well, where an individual was operating a forklift at work. It was a warehouse location in Pennsylvania, and they were injured. So the individual sought damages for injuries caused to his leg, and he alleged that his health was seriously and permanently impaired, that he lost the ability to enjoy life and life's pleasures. So the employer investigated the claim and found a Facebook page and a MySpace page which showed the individual's interests as bike riding. There was a photograph that showed the individual riding his bike after the accident, and the way that they could tell that was that the pictures had the scar that resulted from the workplace injury. So he was riding his motorcycle. They had evidence that he was riding his motorcycle, that he was enjoying the pleasures of life, as opposed to what he said in his deposition after the injury occurred. He also said at his deposition that he would never wear shorts because he was embarrassed of his scar, and they actually found a picture of him wearing shorts with his scar. So, this kind of shows that social media and what's out there in the public can aid in a workplace investigation. In this case, it helps the employer defend itself from this claim.
Yeah, people continue to do stupid things with their social media, and many people continue to maintain public accounts where they put sensitive personal information. I had a case once where the point of this is that social media is not only useful in workplace investigations, but it can also be very useful in litigation. I had a case once where a plaintiff alleged significant emotional trauma and physical trauma to the point where the person said that they could not leave their house. I found that person's public Facebook account, and I found that there was a photo album of the plaintiff in the Caribbean for Christmas to New Year's, drinking on the beach, drinking with friends, riding a horse on the beach, and having a fantastic time. And it was very recent, and during the time that plaintiff had said that they were incapacitated to the point where they couldn't leave their house. And I presented those pictures to opposing counsel, and the case quickly went away. So social media can have very useful information, and if employers use it right, it can lead to discovering inappropriate conduct, lies, falsehoods, misleading information. It can be used for so many different useful ways. Now, Medea is going to talk about the fact that about passwords, and some employers thinking that they can ask for passwords or demand that people show employers their personal private accounts.
Right. So, the first point is that it's important when you're undergoing a workplace investigation to verify the social media information that you found before relying on it. So, giving the individual an opportunity to explain, is this what you posted? There are imposter profiles out there, so that's something to be aware of. Also, Connecticut law prohibits employers from requesting passwords to personal accounts. So that's separate from what's out there in the public. As we said before, if it's public information, it's fair game. But if it's on a personal account and you need a password to access it, employers cannot demand a password, and employers cannot ask the individual to log into a private account in front of the employer or the HR representative. So those are two important points to keep in mind when undergoing workplace investigations. So some ways to maximize the benefit of social media and minimize the risks, because it is twofold, is to implement a social media policy consistently and to apply the practice at the same point of the search in each process, and to treat everybody equally, and to not ask for personal passwords, as we discussed. And another point is to have HR conduct the search, not a manager or a supervisor. So that's really to say that HR professionals are more likely to know what they can and can't consider when looking at a social media page. So that's another point. And then, as we said, consider the source, make sure it's not an imposter profile. Let the person, if it's a current employee, let the individual affirm or disaffirm if they're the ones who made the post before going ahead and making an employment decision.
So what are some of the risks of social media use by employees? And one of the big risks is loss in productivity. And there are numerous studies on this that show that with the internet and connectivity at work, many employees lose hours of what would otherwise be productive working time to monitoring social media feeds. And so that's going to go to the question of whether the company should block social media sites or make it a policy that employees should not use social media during working time. Inappropriate conduct, and we've got a picture of Homer here saying Facebook fight, that means popcorn. Really the point of that is, other than it being entertaining, is that social media brings out the worst in people, and I think that everybody's seen that. You go into a comment section on a Twitter post, and you see some of the most vitriolic, hateful stuff that, from people that you think are otherwise decent, and kind people, and they're just hiding behind a computer screen and saying some stuff that you just can't imagine them ever saying. It can get real nasty on social media, and can that spill over into the workplace? Of course it can. I mean, it's just human nature. So, disclosure of confidential or proprietary information. I've unfortunately had to deal with this on several occasions with my clients where employees either on purpose or inadvertently disclose confidential employer information. Sometimes it could pose liability to the employer, for instance, in the situation where an employee inadvertently discloses PHI, protected health information of other employees, or other confidential personnel information, so that it's out there in the public, and then you have to figure out what you need to do after that disclosure. Or if an employee by accident sends out a financial statement to a third party or to a competitor. I mean, it happens. There's accidents. But also some of this stuff happens on purpose. And with the use of social media and giving employees access to employer social media accounts, it only heightens the opportunity for just this kind of inappropriate dissemination of confidential information. And that goes hand in hand with company liability. Can employers be liable for their employees' actions on social media? Often the answer can be yes, because sometimes employees are in a position of authority where they can bind the company. Their statements can bind the company. So to the extent the employees are acting in their capacity as representatives of the employer, yes, sometimes employees can incur liability for their employers. So these are the risks. These are some of the risks of social media, and you can mitigate some of these risks with appropriate policies and training, but you can't make them completely go away.
So employers have a host of concerns that they have to deal with regards to social media. You know, they have concerns about what can they do if outside of work and after hours on a public social media website, their employees are bad-mouthing their coworkers. They're making disparaging remarks that can damage the company's reputation. It can be bad publicity for the company. Or if the employee shares confidential information that they're not supposed to, that's available to the public. So these are concerns that we will try to address. And what we wanted to do is first discuss two cases that kind of illustrate how social media can play into adverse employment actions. So the first case we'll talk about is one that took place in Pennsylvania. It involved Victoria's Secret stores. The district manager in the store had a public Facebook account, and she held herself out as a Victoria's Secret manager. She had a picture of herself in front of the Victoria's Secret store, and her Facebook profile was public. A anonymous complaint was made on the company's ethics hotline about some disturbing posts that this manager had made. And one of the posts was a picture of a person who was wearing a robe that was reminiscent of the KKK. And so what did the company do? They investigated the ethics complaint, and they were concerned that the post could reflect poorly on Victoria's Secret because the profile identified her as a Victoria's Secret store manager. So after investigating, they concluded that the post was offensive and it violated several company policies. And we wanted to just show briefly some of the policies that the company considered. So first was the Equal Employment Opportunity Policy. And so there was language in there that the company found substantiated making an employment decision based on this inappropriate post. The off-duty conduct policy says that, that the company will take action if there is conduct that might negatively affect the company, and the disciplinary action is up to including termination, even if the conduct occurs off the clock or off the property. So that gave the company grounds to make an employment decision on a post that they had discretion over. And the social media policy for the company also, it made it mandatory for the employee to be respectful, to be ethical, and to be aware of the impact that they were having on social media posts that they were making. So based on these three policies, the company decided to terminate the employee. They did, before they made the termination decision, they allowed the employee to say whether or not she made the post. She did admit to making the post. But she said that the post was actually intended to protest racial discrimination instead of support racial discrimination. So she kind of turned it on its head and said, no, actually I was protesting racial discrimination, but the company still terminated the employee. So when the case came to court before the judge determined, the judge applied the law and said that it's not the intent of the individual who made the post that controls. It's the message that was conveyed, and applied an objective standard that if the post is objectively discriminatory, then there were grounds to terminate the employee. And so that's a really important standard to keep in mind, that it's not what the person intended by their post, it's what other people can perceive the post to relay.
Yeah, and I think this is an example of a case where an employer did everything right. And I think that in this situation, if an employee is using their public platform to identify as an employee of the company and at the same time to espouse racist views, or at least information that could be perceived as racist, the company has every right to terminate the employee or take whatever disciplinary action they deem to be appropriate, especially in light of the policies that Victoria's Secret maintained. They maintained what seems to be a reasonable off-duty conduct policy, civility policy, EEO policy, and social media policy, and Victoria's Secret applied those policies during a workplace investigation and then made what seems to be a reasonably informed decision. And the court agreed with the Victoria's Secret. So I think it's a great example of your hands aren't tied as an employer. If an employee's out there doing silly things on social media that reflects poorly on your company, in many cases, you can do something. Now, later we're going to get into some instances where you can't do anything, and those are the frustrating situations. But we wanted to give you a good example first that at least is encouraging. So, yes. Medea, you've got another example of a case where social media was involved, right?
Yeah, and so this might be an example of where the employer didn't exactly do what they were supposed to do, but it wasn't entirely their fault. So in this case, the plaintiff suffered an injury on the job, so he made a workers' compensation claim, and the individual at the company who was in charge of processing the workers' compensation claims posted on her public Facebook page information about the plaintiff's shoulder injury and the fact that he had been away from work for 11 months. So the plaintiff sued and essentially stated that the company's employee released medical information that was regarding his medical condition and had to be treated as confidential under the ADA. And the court agreed. It said that if the employee took the information from the company's confidential records, that the company itself could be liable under the ADA. And one thing that the court looked at was the fact that this post had been up for 76 days at that point, and I'm not sure if it was taken down after 76 days, but the court was intimating here that the employer almost had a duty to know that the post was up and to do something about it when it knew that there was confidential medical information that was being relayed publicly about their employee.
So that's really an example of a rogue employee posing significant liability to an employer. And again, you can put all the policies you want in place. There's going to be bad actors sometimes that subject your company to a legal exposure. But if you have policies in place and you take actions to mitigate and remediate the situation, at least you'll be putting yourself in the best position to minimize any exposure that the employee causes. So one thing we want to consider, policies We talked a little bit about policies. We're going to talk towards the end about how best practices for social media policies, which I strongly recommend. Hipaa concerns, I think we just touched upon that there can be PHI concerns, dissemination of protected health information over social media, and it can pose significant exposure to an employer. National Labor Relations Act concerns is what we're going to get into next. And if we have time, we'll talk a little bit about free speech, but I want to leave some time for questions as well. So the National Labor Relations Act is really an important topic here. The National Labor Relations Act, for those of you that don't know, the federal act that protects the rights of employees to engage in protected, concerted activity concerning the terms and conditions of their employment. Now, that's a very loaded sentence, and there's a lot of legal terms of art in there. But basically, it allows employees the ability to band together to voice their opinions and their concerns about their working conditions and to fight for better working conditions.
And this applies to both unionized and non-unionized employers.
It's a very important point. The National Labor Relations Act applies to all employers engaged in interstate commerce generally. I don't want to go into the whole jurisdictional test, but most employers are subject to the National Labor Relations Act, whether or not they are unionized. So as an example of a case, so the National Labor Relations Board is the administrative agency that adjudicates complaints, unfair labor practice charges about violations of the National Labor Relations Act. And so here's an example of the National Labor Relations Board, an administrative agency adjudicating a social media case. And this case is the triple play case, which is a pretty well-known case in labor law because it was one of the bigger cases in one of the earlier cases in 2014 to deal with social media. And in triple play, a couple employees started to have a conversation on Facebook about their disenchantment with the owner of the employer. And the owner of the employer had mishandled some of the tax withholdings for these employees, which subjected the employees to some tax liability. They had to make some extra tax payments. And one of the employees ended up calling the owner an a-hole on social media. The owner got wind of it and said, "You're out of here for disloyalty and insubordination." Terminated the employee. The board found that the employee was engaging in protected, concerted activity because the discussion touched upon the terms and conditions of the employee's employment, and they were voicing their displeasure with the employer's handling of this tax situation. So the employer was ordered to reinstate the employee and pay back pay to the employee because the owner had violated that employee's rights under the Act. Since triple play, there have been numerous social media cases at the board, and honestly, the case law has kind of goes different ways every once in a while based on who's sitting on the board. But a very recent example of a social media case, an October 2018 case that was decided by an administrative law judge, I thought was very interesting. In this case, the Roseburg case, concerned an employer who manufactured soft plywood up in Oregon. The employer had an open facility, and the floor was open so that the outside elements could affect the working conditions of the employees. There was a forest fire nearby, and it made the shop floor smoky. This was a unionized employer, and the union maintained a Facebook page. And a union employee started a conversation about the smoky work conditions and started to say some very derogatory things about management. Many of the employees liked the conversation and started to contribute to the conversation, engaged in profanity, saying that the management was some very terrible things about them. Management called in the employee that started the conversation and terminated him for, quote, disloyalty. The judge found that the conduct engagement was protected because it was about safety. It was about the terms and conditions of the employee's employment, and we found that there was no disloyalty. So for it to be for disloyalty to disqualify the protected activity, it has to be malicious and reckless, and it has to really be very egregious. And profanity, derogatory terms about management on Facebook, as long as it's protected, as long as it's concerted activity about terms and conditions of working of the workplace, it's very hard to show that it's not protected. So I thought that was an interesting case because that was a union-maintained Facebook page that was it was a private page, and the page was printed out and brought to management by one of the other employees, and that's how the employer got wind of it. But the employer had to bring back that employee and post a remedial notice and pay back pay. We want to kind of wrap up here and leave about 10 minutes for questions. So let's go over creating and implementing a social media policy before we wrap up.
So let's discuss some best practices for creating a social media policy and we'll do some other best practices as well. So, the social media policy is a good time to remind employees that public or workplace social media activity is not private, and that the employer has the right and, in some cases, the duty to protect unprotected or harmful employee social media use as necessary. So really, the employer has a right to monitor this type of conduct. The social media policy should also talk about how inappropriate posts will be handled, how individuals will be disciplined, and to clarify that the discipline is will not be discriminatory or in retaliation for a protected activity, but it will be to monitor and to maintain a healthy work environment. And also, the policy should talk about compliance with discrimination laws, with the NLRA, and with other laws that might come into play. And
I can touch upon a few bullet points about what I've seen get employers into trouble with the National Labor Relations Board concerning social media policies. One issue I've seen is prohibiting the use or dissemination of confidential info. And to the extent confidential information is not defined in a social media policy, it can be problematic because there are cases where the board has found that confidential info is vague and could be construed to mean that employees can't discuss their salaries and their wages and their benefits. So you have to be careful about referencing confidential information. You want to make sure you define what that means in a policy. Be careful of prohibiting false or misleading statements because that's a loaded term of art under the National Labor Relations Act jurisprudence. Employees can make false statements. They can't make maliciously false or reckless or have a reckless indifference for the truth. And the board's reason that employees might not know that some of the statements they're making are false, but if they make those statements with a reckless indifference to the truth or it's maliciously false, then you can prohibit that type of statement. Two more things. You want to make sure that you reference your equal employment opportunity and non-discrimination policies and tie those into your social media policy. And you also you can put a disclaimer in a social media policy that says that to the extent it conflicts with the National Labor Relations Act, it's severed from the policy. However, the board has made clear that these disclaimers will not save overly broad social media policies. So it's okay to put that in there as a try, but it's not going to be a cure-all. If you want to go way above what the board has said is acceptable and think that a disclaimer is going to save you, it's just not.
So best practices, just quickly, when there is a problematic post, the worst thing I think a company can do is to ignore it. As we said, the employer has a right and a duty to monitor what's out there in the public, and ignoring the issue can cause it to blow up and kind of come in the workplace, either in harassment complaints or spiral into a potential lawsuit, so it really needs to be addressed. Some things that employers can do outside of taking disciplinary action, if a post is made on a third-party website like Facebook, you have the right to request to take the post down. If it's on a company website, there should be a disclaimer where the company reserves the right to remove content that it finds to be inappropriate or in violation of the user terms. If the company can delete the post, it should, or it can reply with correct information. And then finally, legal action is an option if the conduct is egregious enough, but there are obviously drawbacks to that. It can create bad publicity because lawsuits are public, and there's obviously a high cost of litigation. And then finally, when there is an adverse action, we've seen this in some of the lawsuits in the cases that we discussed, but the first step is to investigate, not to draw any conclusions, but first to find out who made the post, whether it was true, what kind of impact it has on the company, whether it can be removed. If there is any discipline, it should be proportionate to the offense. It should be consistently applied to all individuals, and it should be not be discriminatory or retaliatory. Make sure that you're not asking for passwords or to access personal accounts. And consider the content that's being discussed in the post itself and whether terms and conditions of employment are being discussed, which might be protected under the NLRA.
And that can be a difficult assessment, too. Sometimes it's a very fine line of whether a discussion is protected concerted activity or not. Sometimes it's very clear, sometimes it's not, but if you're unsure, I would suggest that you consult with your inside or outside labor counsel before taking any adverse employment actions. So we're going to wrap up the presentation portion of the webinar, and if there are any questions, we'll take a look at those now and see what's out there.
So we have one question.
So one question we have, do you think the employee could have legally been reprimanded for the racist Facebook post if she had not identified herself as an employee of that company? What do you think, Medea? I
think that's a yes. You know, it's not necessary for the person to show on their Facebook page that they're an employee of the company. It's probably knowledge amongst her friends and her connections on that page that she's an employee of the company. And, you know, if it's racist, if it goes against the company policy for social media use, or for if there's a civility policy, then that, you know, termination is strong, but definitely I think there are grounds to investigate. Yeah, and I tend to agree with that. And look, social media, you know, a lot of this, while it is online, sometimes you need to conceptually think about it like, well, what if this person had made this statement in person? What if the person had made a racist statement in person and then during an investigation had admitted to it? I mean, would you fire that person for making racist statements, whether it's online or orally? I mean, and so that's one way to conceptually think about it. Just because it's on Facebook doesn't mean that in substance it's different than having an oral communication or showing coworkers pictures of your KKK meeting. If that's happening and you would otherwise take disciplinary action, then it's probably okay if the same content is appearing on social media. So we have another question saying, I know you referenced the need to authenticate that the social media account is not a fake. My question involves your view for best practices in authenticating content, posts, comments, photos, etc., social media profiles. Is it necessary for court to provide full metadata and file hashtag? Well, that one keeps going on. Is that and file data? So I think the question is, how far do you need to go to authenticate the post before you make a decision? Well, I think there's two different issues you're dealing with there. One is an internal investigation, and two is for court. I mean, to the extent that you can preserve social media metadata, it could be useful. But for purposes of workplace investigation, the first place to start, that's why I put that picture of Homer up there with the to start, press any key, and it says, where's the any key? You have to think about where do you start your workplace investigation. And it's going to the people and talking to them about it.
is this your social media account?
Did
you
make
this
post?
Yeah. And, that's the most basic way of authenticating that. If the person admits it to you and you print it out and you document to the personnel file that you're making a disciplinary or termination decision based on a interview with the person who admitted to their social media account and that they made the post, I think that's fine, and I think that'll be very helpful for court. To the extent that you're on notice of anticipated litigation and you believe somebody's going to sue you, and you have reason to believe that, you do have preservation obligations, and that's a whole different seminar. But for purposes of workplace investigations, you just need to ask the basic questions of who, what, when, where, and why. And if you get admissions, or if you can make credibility determinations that somebody's lying to you based on credible information, I think that's sufficient.
So the next question, we have about 10 more minutes.
Oh, yeah, okay.
The next question is, do you think it's a good idea to document the Facebook review when using this tool to screen candidates? And I think absolutely that's a really good policy and practice to have in place, because information on Facebook pages can change over time, and you want to be able to show, this is the information that we relied upon to make our determination. And, courts can assume that once you've looked at a candidate's online profile, you're aware of whatever information is on there. So, if over time there's different information that's being revealed, and at the time you looked at the post or the page, that information wasn't on there, that would work to your benefit to have a screenshot or a printout of what you did see and what you knew. So I think that's a really good practice to have in place.
Here's another good question. What if inappropriate posts are not public, but are within a Facebook friend group, and someone brings it to our attention, like a coworker or a customer? That's okay. One of the cases I was just talking about, it was a private union group, and a coworker brought the information to the employee's attention. Now, look, if you go out and you try to inappropriately access private accounts and then you get information from those accounts, you're probably going to get yourself in trouble if you're trying to hack people's Facebook accounts to try to do an investigation. I don't recommend you do that. If you come upon private social media postings by way of somebody bringing it to your attention, or somebody emailing it to you, handing it to you, you just seeing it on the internet because it's gone viral, you didn't do anything wrong to come upon that information. Just because somebody makes their account private doesn't mean that they're completely insulated from all actions at work or any adverse criminal actions or anything. I mean, making your profile private is just one step in trying to protect your information. But if you do if you engage in criminal acts on a private Facebook account, you can go to jail for it. You can be prosecuted. If you engage in questionable behavior that violates an employer's lawful policies in a private account, and it comes to the employer's attention, that's okay to take some adverse action against the employee, as long as you didn't do anything inappropriate to obtain access to that information.
So a point that someone wants us to clarify is, are you saying that once you look at an employee's Facebook account, you need to monitor it for changes? No. So that question that I was talking about, monitoring or looking at a Facebook account and whether you should take a screenshot of what you're looking at, only applies to when you're considering the Facebook page when making a hiring decision. And taking a screenshot of that is really just to show what you knew at that moment when you were making the employment decision. You don't need to actively monitor a Facebook account for changes, but there is, as we discussed, the employer has a right and a duty at some point to know, whether there are problematic posts being made on Facebook. So in terms of the hiring decision, all you need to document is what you knew at the time, or what you saw on the Facebook page at the time you were making the hiring decision.
Will you be sending these slides via email following the webinar? Yes. I have no reason to expand upon that answer. Can you share a sample of the social media policy? I don't have a template social media policy that I give to employers, and I'll tell you why. It's not one size fits all. Like I talked about at the beginning of the seminar, I think you really have to think about what makes sense for your particular organization. Because I hate cookie cutter policies. They don't do anything to help an organization. You can find a lot of cookie cutter policies on the internet, and my clients bring me cookie cutter policies that aren't tailored to their organization that they've been implementing for years, and I say, this doesn't have anything to do with your practices or your policies or what you do as a company, and we have to revise them. I'm a big fan of making sure that the policies that we draft for our clients are tailored to the needs of our clients and the business that they conduct. So I don't give out sample policies. What you can do if you're looking for free social media policies, and look, in no way do I advocate somebody trying to do it on their own, because social media policies are a difficult area of the law. But the NLRB has on its website sample policies that it's approved in the past, but they're for very large companies like Walmart is one that I'm aware of. But again, some of those policies that they've approved in the past, the law changes on an ongoing basis, and I don't want anybody out there relying on anything that's outdated or the law's changed and samples that have been approved haven't been taken down off a website. So again, I don't like to see my clients go out there and try to do it themselves on policies, or just go for the cheapest option possible, because an employee handbook and employee policies are extremely important for a number of reasons. And that will lead me to concluding our seminar today. And I'll say that the next seminar I have in mind, and I hope that everybody can join us, is I am going to be putting on a webinar about employment policies and changes to the law on employment policies. We don't have a date for that yet, but we'll be emailing out about that soon. I'm very excited about that because, as I can see from the questions, everybody is excited about social media policies. So we'll talk a little bit more in depth about that and other types of policies and changes in the law when we present on that. So, to conclude, we've come to the end of our program. We hope that you found the information helpful. Medea and I were very happy to present on this topic, and we had a lot of fun putting it together. All of you will be receiving an email with the PowerPoint slides, to the extent we have your correct email address, a link to the webinar, and an attendance certificate. Be on the lookout for that. If you have any additional questions, you can always feel free to reach out to me or to Medea. Hope you enjoyed the presentation, and have a nice Friday and weekend.
Thanks, guys.